Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In my previous video, I have discussed the strict construction of these taxing statutes, and a classic case has come to light, decided by the Honorable Supreme Court of India. When penalty is statutory, when penalty is mandatory, no discretion of the commissioner or the assessing officer. They have to impose the penalty. There is no other go. This was decided in the case of State of Gujarat and another. State of Gujarat and another versus Messrs. Saw Pipes Limited in Civil Appeal number 3481 by 2022, decided on 17th April 2023, just 2 days back, by two judges bench of the Honorable Supreme Court of India, Justice M.R. Shah and B.V. Nagaratna, who held that the moment it is found that a dealer failed to pay the tax, the moment when the court finds that man did not, he failed to pay the tax under section 45 clause 5 of the Gujarat Sales Tax 1969, the penalty under section 45 clause 6. Clause 5 says failure, clause 6 is, please remember, the penalty is automatic and there is no discretion to the assessing officer or the commissioner to levy or not levy any penalty. So this is what I have told you. Strict construction of the taxing statutes. So the taxes are imposed to raise the revenue of the state. To raise the revenue of the state. For what? For public purpose. So taxing statutes must be construed strictly. Here, when the Saw Pipes Limited failed to pay the tax, automatically they have to pay the penalty. There is no leverage given to the assessing officer or the commissioner that due to so and so reasons they are not able to pay, they do not know the consequence, all these things not accepted. They have to pay. The assessing officer cannot use his discretion, right? So the case law you have already seen. Messrs. Saw Pipes Limited. Messrs. Saw, we call it a Jindal Saw Pipe Limited. So this respondent company, Saw Pipes Limited, it is engaged in the business of executing contracts of coal tar pipes, coal tar and also enamel coating on pipes. Because heavy pipes will be there, they need some coating. So they deal with the business, right? It opted to pay lump sum tax under 55A. So because of the business, you may be knowing regarding the so-called GST, they pay some composition tax and some others pay some other type of GST. Like that, these people, they are following the process of paying lump sum tax at the rate of 2%. But please remember, they are doing it under section 55 clause A, right? But please remember, when once the taxing authority, central general sales tax people, they came to the spot, they conducted spot inspection. Ultimately, they came to know that these people are covered under 45, section 45. That means they have to pay tax of 12%. They agreed to pay lump sum tax under section 55. But the inspection of the authorities showed that they have to pay 12% tax according to section 45 clause 5. Now, please remember, when once you come to the conclusion, when once you have established that they come under the purview of 12%, definitely they have to pay the penalty under section 45 clause 6, right? So the assessing officer levied the penalty at the rate of 12% and also the interest against the company. And they are, as usual, the Saw Pipes company, they appealed before the industrial tribunal also. But they also confirmed the act of the High Court, the assessing officer. Later, the matter went to Gujarat High Court. Gujarat High Court reversed the decision of the tribunal and said that since they are paying lump sum tax under 55 of the Act, yes, it should be treated as 2% only. Now the matter has, against to this, Gujarat state has come to the Honorable Supreme Court of India. Supreme Court of India clearly stated that regarding the strict construction of the taxing statutes. Please remember, High Court is not correct. Supreme Court says no option to the High Court, no discretion to the Commissioner, no discretion to the assessing officer. When once you confirm that the person comes within the ambit of Section 45 Clause 5 of the General Sales Tax of Gujarat, then definitely they have to pay, they have to impose the penalty under Section 45 Clause 6. There is no other go. The opinion or the decision of the Gujarat High Court is not correct. That is what is held by Honorable Supreme Court of India. I think you have understood it. So taxing statutes, they should be construed very strictly. There is no other go. There is no chance for taking personal discretion by the commissioner or the SEC officer. With this, I am concluding. Thank you.